Okay, everyone, welcome back. We're in part 3 where we're now going to talk about preventive detention or preventative. I can't spell when I changed it over. Preventative. Fixed. Preventative detention. So I want you to have a think here. What do you do when someone has committed a really, really heinous crime? They've served their time and they're ready for release. Well, the view is that they should be able to be held indefinitely. Some in the community would say if people have not attended classes to try and deal with their issues and move on and rehabilitate and stop doing what they're doing, that they should be able to be held indefinitely. We have discussed this previously in relation to sex offenders and the risk that they can pose to the community. So few crimes engender such fear into the community as sex offenders. Okay, sorry, I'm just looking at something here. So few crimes engender such fear in the community as sex offenders, especially those against children. And this is the one crime that the community will get really, really vocal about. It almost sits as a moral panic due to the amount or the number of extreme reactions that it can cause. I mean, think about what happened with Dennis Ferguson. So we have all these laws that come in that are targeted specifically at sexual predators, and the application of these laws is often based on the predicted dangerousness of the individual and their likelihood of re-offending. So the focus of these laws is on community safety. Now, you can have a look at this site. This isn't a video, it's just a site. And it's about a law that was brought in America called Megan's Law. It was an update of an earlier law called the Jacob Wetling Act, and then it was followed by another one named after a little boy called Adam something. What happened was Megan was 7 when she was raped and killed by a known child sex offender who had moved in across the street from the family without their knowledge. So now in just about every state in America, communities must be warned when sex offenders are in the area. They actually have what's called a public sex offenders register. And we don't have this in Queensland. We actually don't have a fully public sex offenders register in all of Australia. Western Australia have a partially public one where you can apply to get the information, but you won't necessarily be given it. So these laws in America are supposed to be about community safety. And if someone is a clear danger to the community, they may not be released at the end of their sentence. And that is what happens in Queensland. There is talk by the Minister Peter Dutton about having a public sex offenders register in Queensland. I would urge you all to go on to the Griffith University podcasts. I'll try and remember to put a link to them up on the Facebook page. There is an interview done there with Dr. Danielle Harris, who has done a heap of research around sex offenders and recidivism. And she spent a lot of time in America to see exactly how the PSOR, the Public Sex Offender Register, works. And the bottom line is they don't work. And I, for one, am totally against them being introduced in Australia. And there are a lot of reasons, and if you want, we can discuss that in the tutorial. But one thing that happened in America, which I would hope would not happen here, was that a young woman was breastfeeding her baby in public and her breast was exposed, and she is now on a sex offenders register. So I don't think I've ever heard anything so stupid in my life, but that's what happens. All right, let's move on. So we have in Queensland the Dangerous Prisoners Sexual Offenders Act. This came in 2003, and it was only introduced to Parliament 3 days prior to when it was enacted and to when Robert Fardon, who is the subject of our discussion today, was being released. So this permits a prisoner with serious sexual offences to be detained if it's believed that they are a serious danger to the community if they're released. Excuse me. The impetus for this was the release of an individual at the end of the sentence thought to be high risk. Criticisms of the Criminal Law Amendment Act in 1945 to meet community standards and take away focus of control on their sexual instincts that was central to the CLAA. So this was in the past where the focus was on trying to get them to control their urges to protect the community. So the court will now determine whether there is an unacceptable risk if this prisoner is released into the community. They need evidence that they're likely to reoffend, and they're swinging away from the people's condition, which was what it was in the past about controlling their urges or their condition, to their risk potential. So this is where it comes down to having a really good risk assessment tool so that we can move away from looking at the person and treatment options and looking more at what their actual future risk is. And if you can imagine, if we'd have had this in place when Dennis Ferguson was released from prison, there is a very, very good chance that he would not have been released from prison, but would have been kept in. All right, let's meet Robert Fardon. Here is an outline of all the things that he did. Okay, so from 1967, this continued right through until 1989, sentenced to 14 years, expiring on June 27, 2003. So 3 weeks before he was due for release, the DIPSO Act was enacted, and it came into law 3 days before he was due to leave the court or leave prison and be a free man. And he was the first individual to have this act applied to them. An appeal went to the Queensland Court of Appeal, the Attorney General versus him, so the Attorney General on behalf of the Queensland Government and the people. When that was lost, he went for special leave to appeal for the High Court. And again, the High Court cannot make decisions on whether he, as sex offender, is guilty or innocent. They were simply looking at whether the legislation was unconstitutional. And again, that was dismissed. So he argued that the legislation was an affront to his personal liberties as he had served his time. But the High Court decided that it was more about protecting the community than it was about Fardon. So this can, throw up a whole lot of questions about the reasons that we give people jail sentences and why they aren't open-ended, why they have an end date when they're to be released if we go on to say we're going to keep them in prison. So in applying the legislation to Fardon, the judge considered that he had undertaken a number of programs, but had not completed the sex offenders treatment program or a range of other recommended programs. So the view here is that if they don't admit to their crimes and undertake programs, then they are at a higher risk of reoffending. The experts indicated that present scientific tools did not permit a determination with a reasonable degree of accuracy of the likelihood of being violent or reoffending. So sort of accurate, but not 100%. Fairly accurate, so generally accepted. So it wasn't accurate enough. And the psychiatrist recommended against immediate release, while the psychologist suggested a careful risk management plan with intense monitoring may be preferable. So the psychiatrist said no, but the psychologist said yes with conditions. So that makes it difficult for a judge too when you've got push me, pull me going on between the health professionals. Okay, so the judge concluded that there was sufficient evidence to satisfy a substandard of proof, and he was ordered into detention. He applied every year for release. In 2006, he was released on a 10-year order with 32 conditions. One of them was that he had to stay away from schools and young people. For some reason, he decided to join a speaking tour that went to schools, so he was rearrested. Released in 2006, but detained again approximately 7 months later when he breached the terms of his supervision order. Released again in 2007 despite the Attorney General requesting that he continue to be detained. In 2008, he was charged with raping a 61-year-old intellectually disabled woman. He applied for release in 2010, but it was declined. In 2013, he was due to be released again, and the government tried to pass some legislation to try to have him detained, but he was released in 2013 with 34 conditions and lived at a house in Wacol with 2 other sex offenders. He's now in his late 60s, so would probably be thought to be less of a risk, and the research conducted by Danielle Harris in America shows that the longer it is since their last offence and as they get older, they are less likely to reoffend. In 2018, he was granted the right to live independently in the community with no restrictions. State government appealed it and it went to court and they actually lost. He's now over 70. He already has been in the community where he's been living and he has not committed any further offences. Statistically speaking, he is not likely to offend again, but the community is wary and want him to have controls in his life. So I've got a couple of YouTube clips there. They're news clips so that you can get a little bit of background on Robert Fardin. The media being the media, you'll see in one of the clips they chased him down, they followed him on a train, said to him about the way he was looking at a woman. He just glanced at her. So, you know, the media, as per usual, beat this all up. But have a look and see what you think. And we're going to discuss Robert Fardin a bit more in the tutorial. So what are the issues? Because it is not an easy thing to do. Well, the risk relates to the likelihood, and dangerousness relates to the consequences of offending. So, for example, an offender might have a 5% chance of reoffending, which is really, really low. But the offence is likely to be murder, which is really, really dangerous. So what do we do? An offender might have a 90% chance of reoffending, which is really, really high, but the offence is likely to be shoplifting, which is really, really nothing. So, well, it is something, but it's not as serious murdering someone. So there are issues in assessing risk and dangerousness. Risk and dangerousness are dynamic constructs. So people just simply don't behave the same way in all circumstances. As I mentioned before, think about how drugs and alcohol can change the way people behave when they're under the influences. Risk factors can carry different weights. Some are really strong and some are just correlated. Some might be something just going on at that particular time in their life. But what about protective factors? So not everyone with the risk factors is offending. So what is the difference? And cumulative risk. We see many of the risk factors together. Can be how many risk factors you have and not particularly what they are. So the more you have, the more cumulative you have, the more you are at risk. And poor ability to predict violence in the absence of previous violence. Well, what if you haven't committed a violent act? Difficult to predict before it happens, and people change. You could be assessed at 30 for being high risk for something that happened at schoolies when you were 18 and being stupid, when you're actually at 30, no risk whatsoever. And what are the definitions of recidivism? So there are issues there in assessing risk and dangerousness. Okay, so this is what we have learnt today. Practitioners have a general duty to warn or protect people at risk of harm from clients. Risk and dangerousness are separate constructs which the CJS tries to predict. Risk prediction is difficult, so clinicians tend to over-predict and make false positives, where they say that they won't, false positive, where they say that they won't reoffend and they actually do. Numerous instruments are available that vary in success. A combination of actuarial measures and clinically relevant variables is the most common approach. Predictions of risk and dangerousness have major implications for the community and for offenders. And while considerable progress has been made in the area of risk assessment, this is an area of psychology still facing major challenges. Okay, that's it for week 11. We're done. No more new content for you. And next week, no lectures for you to listen to beforehand. we will just cover everything in tutorial and workshop. So I will see you then.